Good morning, everybody, and welcome to this morning's webinar. It's a webinar about revised CEN and CENELEC Guide 8 on the so-called CEPs, the standard essential patents. We start at 10 this morning. Maybe I would like to, can I have the second slide, Spiro, please? I would like to tell you something about today, because today is Pink Monday. Pink Monday is in fact, the Pink Ribbon Association that is doing research against breast cancer. And the three speakers, well, the two speakers and myself are showing our support for the Pink Ribbon Association today, as you can see on this slide. So, as usual, during this webinar, you will be muted. It's normally mentioned on the second slide, Spiro, please. Yes, that's me. I'm the webinar moderator, so any questions that will pop up, I will moderate a bit together with the speakers. Like I said, as usual, you're muted during the presentation, but you have the possibility to enter your questions already while the speakers are talking via the Q&A panel of the GoToWebinar. Should you be on Twitter, please feel free to tweet about the topic. Our handle is @standards4EU. So let me now take some time to present you the speakers. First of all, there is my colleague Spiro Dappi, who is a project manager, legal affairs in the strategy and governance department at CEN and CENELEC. And we have an external speaker, Mr. Jed Owens. He's a coordinator in international cooperation at the European Patent Office. So please, gentlemen, the floor is yours.
Thank you, Els. Good morning, everyone. It's a pleasure to be here today, also with our guest, Jed Owens from the European Patent Office. We thought that this was a very good opportunity to have this webinar this time, following the update and the revision of the CEN-CENELEC guide on the implementation of the policy on patents, but also considering the various discussions which have been taking place at European level, international, of course, as well, with regard to standard essential patents, the policies of the standardization organizations with that respect, the involvement of various stakeholders, and how this will go on in the next step as well. Okay, so the first thing is to understand a bit more what are the intellectual property rights. This is just a very brief introduction. IPR refers essentially to some various types of temporary property rights which are recognized by the law. These are in the form of intangible assets, for example, musical, literary, artistic works, discoveries and inventions, words, phrases, symbols, and design. The most common types of intellectual property rights include the copyrights, trademarks, patent, industrial designs, and domain names. Probably you have already heard some or many or all of these types of intellectual property rights. They're recognized by law. Basically, the law has granted these exclusive rights to the owners in order to reward them for the fact that they have contributed some creative work or innovative work towards the implementation of specific technologies for the benefit of society as well. There are, of course, differences in the protection and the rights given for each type of intellectual property rights, but this is not something we will discuss in general today. We will focus today mainly on the patents aspect. So what we will focus today is to understand a bit the patents in CEN-CENELEC as a context, the digitally transforming industry, the issue of the patent holder versus standard user, the revised CEN-CENELEC Guide 8 as well. And of course, we will have the presentation from Jed, who is our colleague from the European Patent Office, to give us a bit of context to understand a bit how things are evolving also from the side of the European Patent Office. So first thing, patent is defined in the law as a set of exclusive rights granted by a national authority to an inventor for a limited period of time, usually it's around 20 years, in exchange for the public disclosure of an invention. So essentially, in the case of patents, the law grants the owners of the patents some exclusive rights the ability to exclude others from their use with the return of the disclosure of this invention to the public, aiming that this technology will be used for the benefit of society and the general public as well. So this is a very strictly defined and limited context. The European Patent Office is dealing on a daily basis with many of such applications for patents, and they also go through these specific criteria as they're defined in the law in order to determine if there is indeed such possibility to grant a patent or not, because very often applicants do not fulfill the requirements of the law for the determination of patents. So there are three elements, simple concepts, which define what can be granted as a patent. The patent invention has to be novel. Basically, it should be comprised for something new, not state of the art, not something which pre-existed. It has to be an inventive creation, meaning that it has to be an ingenious device or a process. And then also it has to be subject to possible industrial applications. Of course, these are some rough definitions. Depending on the country and the legislation of that country or territory, there might be differences with regard to the conditions to grant such licenses. Also, for that has to be taken into account the court background, so the court cases, the case law in that country and jurisdiction, and also in the case of the European Patent Office, the practices and previous decisions of the European Patent Office for that. Now, we thought that it would be interesting also to start after from the definition of the patent to a more general context to understand why patents are important in the standardization world today, particularly with regard to the new technologies. So with regard to the fourth industrial revolution, we see that in the case of the smart connected devices, there is a growth rate of 54% in the last 3 years prior to 2017 with regard to the patent applications. And this is data that we collected from the annual report of the European Patent Office. Therefore, we see that gradually throughout the latest years, there has been a dramatic increase to the number of patent applications in the areas of connected devices. Also, there are more than 5,000 patent applications for inventions relating to autonomous objects. And these applications were filed also in 2016 with the European Patent Office. So we see, therefore, that there is a trend towards standards and patents being more closely linked together in the areas of standards and research. We see also that the more the complexity of the technologies is increasing, also the complexity of the standard is increasing as well. So there are also technologies which before were not part of the common of the past type of standards. Now they're increasingly being integrated into the new standards in the traditional areas that we have right now, and that is part of the new trends in the Internet of Things, the device-to-device communication, and the need for interoperability in the technological sectors and the European and global economy as well. So these trends where new technologies are becoming increasingly disruptive or introduced in traditional areas of standardization create the need of addressing this specific relationship between standards and patents. And then while today we see that this relationship mainly arises in the areas of telecommunications, for example, the Wi-Fi, we see in the areas of ICT and computer, audio and video coding standards, there is a growing interest for essential patents in the areas of automotive and smart sectors. And soon, as I mentioned earlier, Internet of Things, machine-to-machine communication, device-to-device communications, these are areas which are becoming increasingly linked towards the relationship between standards and patents. Now, a very interesting study here from McKinsey. This study showed that the IoT systems could have a very important impact to the global economy. And out of that potential impact, they predict that around 4 trillion US dollars out of 11 trillion, they are linked to the interoperability of these IoT systems. Therefore, considering the importance of the standards in order to ensure interoperability, this type of growth in the economy can be directly linked with the fact that standards need to be used in that area, and these standards also relate to patents which are registered, which are either granted or have been requests for application at the relevant patent offices. Therefore, we see there is an important consideration here from legal that we mentioned earlier, but also from economic and political perspective to this relationship between standards and patents. And with that, I will give the floor to our colleague Jed Owens from the European Patent Office, and he can continue on the presentation with regard to the patents and standards in the Internet of Things and the EPO's approach in optimizing patent quality and increasing the transparency with that regard. Jed, can you hear me?
Yes, Spiro, thank you very much.
Great.
I hope
It's
you
all
can hear
yours,
me.
Jed.
All right, thank you very much. Good morning to everybody, and I hope this is a good start to the week. Let me just make sure that my screen is presenting properly. Spiro, can you now see this?
Yes, just a suggestion, if you could choose, please, not the project option on the lower screen, but it is the read, I believe, version. In the lower screen where you have the PPT, there is an option there which says slideshow, and the other one which is reading view.
Okay.
It shows better on the screen.
So if I go to view, and I'm looking for reading view.
No, it's on the lower right corner.
That one.
Okay. Okay, so let me flick through quickly.
Excellent.
All right, these are typical starting issues. So thank you very much. My name is Jed Owens. I'm the coordinator for patents and standards at the EPO. We've been working with standards organizations for about 15 years now. In particular, ETSI, 3GPP, the IEEE SA, and so on. But we work very closely with CEN-CENELEC, as well as ETSI these days, as well as the European Commission, to ensure that we have a harmonized approach to patents and standards in Europe and across the different areas of technology. So thank you, Spiro, and thank you, Els, for this very, very important introduction. We are now going into the fourth industrial revolution, and as Spiro, as you were saying, ICT, so information and communication technologies, are now finding themselves into all sorts of different areas, and the interoperability which is required between these ICT systems requires standards, and those standards, because they're the latest technologies, they tend to be patented these days. So we have a unique approach among patent offices to patents and standards. We've been cooperating for around 15 years with various different standards development organizations, and it started in particular with ETSI, the European Telecommunications Standards Institute. And our main roles are to optimize the patent quality for the granted patents in these areas and to increase the transparency surrounding standard essential patents. In other words, to be able to indicate to people which are the standard essential patents in each area and make it easier then for people to see in which geographical jurisdictions those patents are filed and whether they're still valid, whether they're granted or not, and whether they are upheld over the potential 20-year life of the patents. So we started working with ETSI in around 2003, partly because our examiners that were coming from these technical areas were saying, but we're receiving patent applications which have already been disclosed and discussed openly in standards development discussions. And we're now seeing people trying to patent technologies which have been offered and which have been discussed at standards bodies, and that is not right. Therefore, we need to start to gather the standards development documentation from those meetings and only to grant patents to the people who are the genuine inventors of these technologies, and they should have filed the patent applications before these standards meetings. Our European cooperation today extends to the European Commission and to CEN-CENELEC as well, so that we cover all of the different standards areas across the technologies. And we're also, it's very important for us to work with the European Commission these days because of their digital single market concept and for the development of the Internet of Things and the Fourth Industrial Revolution. So we work not only with ETSI and CEN-CENELEC, but with ITU, with the IEC, the International Electrotechnology Commission in Geneva, the IEEE SA, the Internet Engineering Task Force, W3C, which basically governs the www World Wide Web standards, digital broadcast organizations, as well as the Bundessicherheitsinstitute. And our cooperation is increasing with different standards organizations all the time as standards become more important in, for instance, the automobile and mechatronics area. So we have a well-established practice in the use of the standards documentation as prior art. So we search standards documentations all the time as part of the granting procedure. This optimizes the patent quality. It increases the patent transparency because then you only have granted patents which are genuinely inventive and they've not been basically filed after discussions at standards organizations. And this avoids a lot of costly litigation then in courts at a later date. The type of standards documents that we gather are not just the final standards, but we go right to the beginning of the process where technical contributions to standards are the most important technical disclosures and the earliest technical disclosures of technologies that might be used. We then follow this process into the draft specifications, and we even use the minutes and meetings reports sometimes to help indicate to us what are the most important technical standards in any particular standards development area. In principle, these types of documents forms part of the state of the art under Article 54.2 of the European Patent Convention, unless there are confidentiality obligations or participation is restricted to a very small number of people. Now, exactly where the borderline there is defined through general practice over the last 50 years, but also through a number of Board of Appeal decisions which are relevant in this area. So ideally, standards development organizations should have a document handling policy, which includes templates. That allows us to see very clearly who the authors and who the, if we like, the proposers of technical solutions were. Also very important is the date of disclosure for us, because that's the date which is so crucial as to whether it is before or after a patent filing or priority date. We incorporate these standards documents into our internal databases, and we have an ever-larging collection of these documents in our internal searching databases. We now have around 3.5 million documents, which are standards documents and standards development documents in our internal databases. And you can see very clearly from this graph how that has increased from when we started gathering this in 2007 until the current date. And as we expand the number of standards organizations that we deal with, as well as the range of technologies in each of those, it just will go on increasing into the future. This diagram actually shows the number of documents that we cite in our search reports against standard essential patents. In 2018, it was around 28,000 documents. We expect that again to be much larger by the end of 2019, but 2017 to 2018 was a 22% increase. This, of course, altogether, we probably cite around 5 million citations per year. Sorry, about 1 million citations per year, I beg your pardon. So the 22,000 or 28,000 doesn't seem to be so great a number in this way, but in certain key technical areas, such as Wi-Fi or digital video coding and compression, such as MPEG, JPEG, etc., up to 60% of the search reports will contain at least one standards document on that search report. Now, this enhancing of transparency in SDO databases and the use of the documentation there is something which is even discussed now at the European Union level. So the European Union Council stresses the importance of increasing the transparency of SDO's databases and calls on standards development organizations to update their declaration system in collaboration with the Commission and other public authorities, including, where applicable, intellectual property offices such as the EPO, and via links to our databases to increase the transparency around standards essential patents. There is a link directly between the ETSI Standard Essential Patent Declaration database, as well as the ITU database, into the EPO's patent information services. And then you can see directly the documents in the EPO databases, the patent family across, for instance, America, Japan, China, Korea, and other important states, and what we call the legal status of those patents, whether they're still upheld, whether they're still in force or not. So this increases the SEP transparency through a very user-friendly public accessibility and the connecting of the databases. Now, not every standards development organization has such a database, and not every SDO requires their members to specifically define the SEPs. Some people have blanket declarations and not specific declarations, but as the patents and standards important continues, then we'll increasingly find that SEPs, that SDOs do have specific databases, and this transparency becomes increasingly important. So this directly shows you on the left, the ETSI Standard Essential Patent Database, and in that you'll see the patent families. That information is derived from the EPO databases, and if you click on any of the patent numbers in the ETSI SEP Declaration database, then it will move directly and open our ESPASnet public database, which contains 110 million patent documents from about 100 different jurisdictions and countries. And there you will see the bibliographic data, when a patent is filed, the priority date, the titles, the applicants, the inventors, and you'll also be able to see the patent family information, how widely geographically that is filed across the world, and also for each one of those documents, the IMPADOC legal status, whether that patent is upheld or not. So here again is a slide from the IMPADOC database, which shows the actual legal status of whether a patent is upheld or not. And there we have the legal status data from around 57 authorities of the 100 from which we have the patent documentation. And this is increasing all the time. So that's the end of that presentation. Thank you very much to Els and to Spiro Dapi for giving us the opportunity to present the information, and we look very much forward to your questions after the event. Thank you very much.
Thank you, Jed. By the way, if you have any questions, as my colleague Els mentioned at the beginning, you will have the opportunity already to submit these questions on the webinar part. You will see on the side there of the application, there is a box with questions where you can submit them already. This way we can start taking stock of the questions, and at the end of the presentation, we will respond to those questions. At the same time, I would like to a bit summarize what we heard this far, because we had the presentation from Jed, and I think what is important out of that is that the role of the patent offices, and particularly of the European Patent Office, I would say is twofold. On the one side, we see that the patent registration, so the patent applications or the granted patents the information for this type of registrations is important because the patent owners can provide these informations to the standards organizations in order to be able to register this information in their databases of declared patents. At the same time, the second part is that the relevant discussions at technical level with regard to specific technologies can be used by the patent office, the European Patent Office in this case, as a source of information to identify prior art. And the reason for that is because, as I mentioned at the beginning of the presentation, only those patents which are new, all those technologies which are new and not prior art can be granted as patents. Therefore, someone, what it means in practice, someone cannot register as a patent something which pre-existed, a technology which pre-existed, and then when this technology was included in a standard and was never registered as a patent, there was no application for a patent at the European Patent Office or other patent office, then this means essentially that it cannot be registered as a patent by itself. So there is a double role there for the European patent offices and the collaboration with the standardization organizations. And by the way, to mention that we have already established an MOU with the European Patent Office between CEN-CENELEC and the EPO, and the aim of this collaboration is a first layer collaboration to increase the flow of information and the quality of information on patents in the relevant communities of CEN-CENELEC and the European Patent Office. And then this webinar, in fact, is part of this collaboration to ensure that the experts and stakeholders participating in the CEN-CENELEC community are also able to see what is the implications, what are the implications from the inclusion of patents and standards, what are the considerations that the European Patent Office takes, and what its role in these discussions are at the moment. So thank you very much, Jed, for this intervention. So going further on, as I mentioned earlier, there are increasing trends towards the inclusion of patents in relation to standards, and we see that there are also some tensions there created between the owners of those patents and the implementers of the standards. And the reason is because when a standard is being developed and a technical committee may decide to include a technology in the standard, which technology is in fact either protected already by a granted standard or under a standard which has been, there is an application to be granted, then in case this technology will be included in the final standard, then any implementer who may need to take the standard and implement it in the context of their business, then they may need to in fact use this patent in order to be able to implement the standard. So in this case, we are getting in the sphere of what we call standard essential patents. So essential, calling those patents which, according to the view of the patent owner, can need to be used, are essential for the use and implementation of the standard itself. Now, here we have included some cases where there are some tensions there between the owners of the patents and the implementers. So we will explain the cases of the patent ambush, the case of the patent shark and trolling, the royalty stacking, and the patent holdup. So these are some cases which have arisen in practice and is situations where need to be avoided as much as possible. So in the case of the patent ambush, what happens here is that there is a standard, for example, which is being developed, and then in that development phase, someone proposes a specific technology to be included, to be referenced in the standard. It is possible that this technology may be proposed by the owner of a patent who actually has an interest to include such patent in the specific standard. However, there is in case this patent owner does not disclose that this technology is in fact protected under a patent and does not agree to make a declaration to the standards organizations for this patent technology, then there is what we would describe a deceptive and non-transparent conduct, since this is used as a tactic in order to ambush the users after the adoption and implementation of the standard. This is a conduct which is certainly negative, and under the CEN-CENELEC Guide 8, which includes the policies on the patent cases, this type of behaviors are not encouraged. Therefore, what we encourage is that anyone that is aware of a patent at the beginning of the development work, during development work, or even after, is encouraged to inform that there is such a patent which protects the technology which is being proposed for inclusion in the standard. This is even more for if someone is the owner of that patent. So if someone is an owner of a patent and participates in the technical committee work, they are strongly encouraged to inform about these patents in order to avoid such situations of patent ambush. Another situation is the patent sharks or trolls. In this case, the patent holder is not a member of the technical committee or is not participating in the technical committee work. They're not obliged to respect the CEN-CENELEC policy with regard to fair, reasonable, and non-discriminatory terms. However, they assert their patent rights after the standard is widely implemented by companies. Essentially, this is a very difficult scenario because the patent policy cannot be asserted against someone who has not participated in the technical committee work. What is encouraged in this case is that any expert participating and who may have knowledge of any other party's patents which could be relevant for inclusion in the specific standard under development, they are strongly encouraged to inform the chairs of the technical committees about the existence of this patent. So if someone, even if someone is not participating, however, there might be knowledge among the experts that there is actually such patent, then it is strongly encouraged to include such declaration or a notice to the technical committee. And then this is important because there might be organizations which own large numbers of patents, and their business model may be focused on the licensing of these patents. They may not actually be involved in technical work itself. Therefore, it could be a possibility that they do not actually participate in technical committee work. Another scenario, it is the scenario of the case of the royalty stacking. What happens in this case is that there are too many patents which are relevant for the implementation of a specific standard. Therefore, the implementation of the standard might be very expensive for the implementers. This is a negative effect on the pricing of the downstream product of the market. There are often argumentations expressed by the implementers saying that this is getting very difficult implementation of the standard. One of the solutions that could be considered in this case is the patent pooling. Essentially, the various owners of the patents which are relevant for the same standard, they can come together and agree to develop a patent pool or to cross-license standards with that regard. This is an aspect which also has been referenced as a possibility in the new CEN-CENELEC, the revised CEN-CENELEC Guide 8 on the implementation of the patent policy. So this is also a possible scenario. We haven't seen very much in case of CEN and CENELEC because there are very few patent declarations in the CEN-CENELEC system. Most declarations take place at the international level, usually at ISO and IC level. We have seen in the case of ETSI, there are many declarations as well, and it is possible that for the same standard or same clauses of the standard, there might be a large number, in fact, of patents that could be relevant, which could make the implementation quite expensive with that regard. Now, another case that may arise is the scenario of the patent holder. Essentially, what happens in this case is the patent holder is demanding a higher royalty rate than he or she could have negotiated if the patent was not essential for the standard. So what this means in practice is that a standard is being developed, someone proposes at the beginning a technology to be included in the standard, which in fact is protected by the patent of this contributor. And eventually, once the standard is being adopted and technology is being also included in that standard, then this may add additional value to the patent technology, and therefore the patent owner may request in these cases more royalties, increased royalties compared to what they would have requested in case the patent wasn't included in that specific standard. So what can be done about this case? The policy that has been implemented by CEN-CENELEC also is the same policy at ISO, IC, and ITU level, is the FRAND policy. So anyone who wishes to include technology in the standard is required to declare this patent and then also to commit in the licensing conditions. And then one of the options is also the FRAND. FRAND is for fair, reasonable, and non-discriminatory conditions. Of course, this has created many litigations, and the reason for that is because it is not defined what FRAND is. Actually, it is something quite vague in practice. The standards organizations are not involved in the specific licensing conditions and the licensing terms. This is left between the patent owners and the implementers. And also, as you see, what is maybe considered reasonable from one party may not necessarily be reasonable for a second party. And what is a fair price today may not be a fair price tomorrow. And also we see that there are discussions at the same time, what should be the fair price? Should there be a common base or not? Should it be defined on the value of the end product, or should it be defined on something else? So this is a big discussion which is taking place right now at global level, because the interests between patent owners and implementers, in some cases the same organization could also be patent owner and patent implementer, so it really depends on their business model what could be the implications for their context as well. So this is something which in fact is left to the implementers and patent owners, however is something which needs to take into account. Now, from the side of the standards organizations, in this case of CEN and CENELEC, what needs to be ensured and is included in the CEN-CENELEC Guide 8 is that there should be a declaration as early as possible. What this means is that it is very important that whoever is an owner of a patent or whoever is aware that there is a patent needs to inform the technical committee in order to ensure that the patent owner will be contacted and requested to fill in the declaration, which we will explain later. And this declaration requests from the patent owner to inform what is the patent, provide information about the patent and the standard which is concerned, and also to declare the specific conditions. The FRAND commitment is also very important. This is a key element of the CEN-CENELEC policy. Essentially, this commits the patent owner to give a license under fair, reasonable, and non-discriminatory terms. As I mentioned, this is a very general concept. It does not specify what are the specific licensing conditions. However, at least at this level, it is important to ensure there is an appropriate framework in place, and FRAND provides this appropriate framework in place to ensure that there is a smooth implementation of the relevant standards. Also, it is very important that the CEN and CENELEC have complete information which they can provide in their patent lists and databases. This is very important because it links also with the other element which we have there, which is transparency. When CEN and CENELEC have sufficient and complete information, they're able to make this information available to the implementers. This increases transparency, and the implementers have the necessary tools themselves in order to be able to implement the standards in their context without being prohibited due to the fact that there are patents which could be relevant and they need to license it for that respect. It is very important, therefore, that this information is being provided to CEN and CENELEC. We request that the patent owner provide us as much information as possible, so that in turn CEN and CENELEC can also make this available to the users of the standards. Another element which is also very important is the cooperation between the involved organizations and stakeholders. CEN and CENELEC endeavor at all cases to ensure that there is a discussion and continued dialogue between CEN, CENELEC, the various implementers, the patent owners as well, and we are constantly involved in policy discussions which are taking place. There are some developments during the last period on this area of patent standards and the front licensing. CEN and CENELEC are participating in these discussions and ensure that there is also input provided whenever that is necessary, including, of course, with the European Commission and EFTA. And the final part is also very critical here, the balancing of the interests. From one side, it is important that the best technologies are included in the standards. At the same time, it needs to be ensured that the implementers, the users of the standards, are able to take the standards in their context and implement them without limitations, which, of course, are not reasonable. So the role of CEN and CENELEC in this case is quite sensitive. We are somewhere in the middle, where the expertise in the community is to develop standards. It's not about patents. Therefore, what we need to do is that sufficient information is provided from our side. At the same time, we have a policy framework in the context of FRAND, which ensures that any patent technology will be able to be used under fair, reasonable, and non-discriminatory terms to the user. So this is a very important and tricky part here. However, we have seen that this balancing is something which has been working. As I mentioned earlier, considering the new trends in technology, it might be likely that there might be more patents arising, coming up in traditional sectors, which they haven't come before. Therefore, if you're experts, chairs, conveners of technical groups, please be aware that these issues have to be flagged whenever they are relevant, in order to ensure exactly that at the same time the best technology, state of the art, is included, the patent owners are rewarded for their inventions. At the same time, the implementers are also able to use the standards as widely as possible, and this is important both for CEN-CENELEC, but also for our stakeholders, so European Commission and other organizations involved in the system. As I mentioned earlier, the CEN-CENELEC patent policy is based on the ISO IC and ITU common patent policy. The CEN-CENELEC Guide 8 is a guide on the implementation of this common policy of patents. As I mentioned, some key principles here is that there is a voluntary L declaration at the best of the expert's knowledge. So anyone who has knowledge of the existence of patents which could be essential are invited to provide this information to the relevant technical committee chairs. Also, technical committee chairs need at the beginning of each meeting to request and invite anyone in the meeting to inform if there is any patent which could be essential, and this information is recorded also in the minutes of the meetings. This is also very important for transparency as well. Now, essentiality is determined. What is essential is something which also is not always, or in most cases, clear. Therefore, essentiality is determined based on the opinion of the owner of the patents. They declare what they believe is essential. Now, if there are any disputes, this is left between the parties and the relevant courts in order to address, because very often there are disputes between the patent owners and implementers with regard to the validity of the patent, or maybe the patent claims are not based on the opinion of the implementer, maybe are not covering the specific standard. So these are things which are being addressed in case of disputes between the parties at national courts or in alternative dispute resolution mechanisms. Now, in the case of CEN-CENELEC, we examine the relevance of the declared patents, but we do not examine essentiality. We do not examine the scope, the validity, or the terms of the licensing which is being provided. So, as I mentioned earlier, the expertise in the CEN and CENELEC system is about standardization. The experts in technical committees are not patent experts. This is not something they can deliver. What they can do is consider if there are any patents and provide this information, and then contact the CEN-CENELEC can contact then the relevant patent owners in order to request this declaration. So we do not determine scope or the validity of the patent, if the patent claims are valid or not, or the terms. Also, what we ensure is the front conditions. That is very important, as I mentioned, that the patent owner has committed to provide, the patent owner and its successors have committed to provide a front license to anyone who will approach them in order to implement the specific standard. This is very, very important. Now, as I mentioned earlier, what do we consider essential? Essential is something which is not possible according to the patent holder at the time of the standardization making process to make a product or method according to the standard without infringing the patent holder's right on the patent. So essentially, what it means is that you cannot implement the standard without using the specific patent technology, and this based on the view of the patent holder at the time of the development of the standard. So this makes the patent assessor. So this is the SEPs process. Now, patents for which licensing conditions are declared, they have to be done in accordance with the CEN-CENELEC Guide 8. They have to fill a declaration form. In this declaration, they have various options. One of the options is the front conditions, as I mentioned earlier. And also, in case of the transfer of the essential patent, this commitment and declaration also commit the successors. And this is very important because it is often the case that patents are being transferred, the rights to the patents are being transferred from one owner to the other. Therefore, it is important that one declaration which is made at the standards organization also commits the successors in rights for this same patent. Now, how does declaration look like in the case of CEN-CENELEC? So we give three options essentially in the case of the CEN-CENELEC declaration. The first option is that the patent can be granted free of charge. So in some cases, it is possible that the patent owner is not interested to license a patent under a fee. Their business model maybe is to provide standards free of charge, for example. However, in fact, they may provide services on top of that particular technology. This is very important. They have the option to agree to that here. Of course, there might be some additional conditions associated with that. For example, reciprocity. The patent owner may say that I agree to license free of charge. However, only on the condition that also the implementer will agree to license their patents on the same conditions or under front, for example. This is something which can be chosen here. The options are provided in the patent declaration. Now, of course, free of charge doesn't mean that anyone can simply implement it just like that. The patent owner may still request that there is a license. Even this license, basically the license is like a contract between the patent owner and the implementer. So in these cases, the patent owner may request that there should be a license even free of charge. So without determining fees, but there might be a framework, a contractual framework in that place. The second option which is granted here is the possibility to license under fair, reasonable, and non-discriminatory conditions, so the front framework. Also, this possibility may be linked to reciprocity. So the patent owner may say that I would like to license under front terms, however, only on the condition that in case the patent, the implementer of the standard and end of the patent may have patents also which are relevant for the standard, then only if they also agree to reciprocal licensing of their patents, then I could agree also on the front conditions here. And this is very important. And then the third option, which is also equally important, is the patent holder may inform that actually they do not wish to license their patent under free of charge or front. This is very important because, and this is the importance also of the early declaration, because when the patent owner may inform that actually they do not wish to license a patent under any of these conditions, then this information needs to be transferred to the technical committee of CEN-CENELEC so that the technical committee will be able to consider options for a design around this specific patented technology. So the technical committee will essentially try to find a way to avoid the inclusion of this specific technology in the standard, exactly because the standard is important to be used as widely as possible. Therefore, if there is no commitment for FRAND or for free of charge licensing, then this would not be possible for the implementers. Therefore, if any patent holder refuses to sign this declaration, therefore the technical committee needs to consider other technology which can avoid the specific patent. And by the way, as I mentioned, you might have some questions. Therefore, please submit your questions already online so that in a bit we're going to start reviewing your questions and address them one by one with Jed. The patent declaration, as I mentioned, the list of the patent declarations is provided on the CEN-CENELEC website. This is the database that also Jed mentioned earlier, the databases that SDOs are providing. In the case of CEN-CENELEC, there are not as many declarations as you would see in the case of ISO, IC, or ETSI. However, as I mentioned, there might be trends coming up where these declarations could increase. In any case, all the information about the declarations are provided on the CEN-CENELEC website on a dedicated part about IPR and patents. As I mentioned earlier, the design around is also very important, because if the patent holder doesn't commit to license, then there is a possibility to consider other technologies with that regard. Now, at the same time, as I mentioned, there have been various discussions at policy level, and CEN-CENELEC have been very involved with that regard. In 2015, CEN-CENELEC, ISO, and IC issued a response to the European Commission's public consultation on patents and standards. There was a consultation back then with the European Commission in order to discuss any initiatives with regards to the framework at the European level for standard essential patents. Also in 2016, CEN-CENELEC issued a position paper for the FRAND commitments and the relevant European initiatives in this domain. So what we want to get out of this is that CEN-CENELEC remain very active in these discussions, and the reason is because this is a very important topic for both patent owners, but also for standards implementers. And in order to ensure that there is the appropriate balancing of the interests, CEN-CENELEC stay committed to be in discussions and dialogue with the various stakeholders to ensure that their considerations are also taken into account in the various initiatives from CEN-CENELEC. As you may have already seen, in 2017 there was a European Commission communication on standardization of digital single market in the ICT. Also, CEN-CENELEC wish and endeavor to collaborate with also ETSI, ISO, IC, and the European Patent Office in order to clarify core elements of the equitable, effective, and enforceable licensing methodology around FRAND principles. So CEN-CENELEC are taking into consideration the various discussions which are taking place with that regard. So this position paper also confirms the existing rules that it is indispensable to commit to the FRAND conditions, that CEN-CENELEC do not assess patent essentiality. As I mentioned, there is no such expertise. It's not the expertise of CEN-CENELEC to determine essentiality of the patents. This is left to the patent owners based on the current policy, and there is no interference with the licensing negotiations. So the licensing negotiations are left between the patent owners and the implementers of the standard. Now, taking into account this background and the discussions which have been taken into place, CEN-CENELEC revised the CEN-CENELEC Guide 8 of 2010 on the implementation of the patent policy, and the aim is to ensure that the patent holders are able to provide complete and updated information. These were some, I would say, changes which did not affect the core of the principles, which is, as I mentioned, FRAND, about the possibility for declarations. The declarations are the essentiality is determined by the owners, not by CEN-CENELEC. What we did in this revision is to ensure that there is adequate information to be provided to the patent owners, and also to address relevant aspects which were raised by the EC communication, the European Commission communication, on setting out the EU approach to standard essential patents. This communication by the European Commission provided some proposals addressed to all stakeholders, including the European standardization organizations. These considerations were taken into account. There were discussions with that regard with the European Commission, also discussions internally in the CEN-CENELEC community and stakeholders, and based on this feedback, a proposal for the revised and updated CEN-CENELEC Guide 8 was provided to the governance of CEN-CENELEC, and was adopted this year in 2019. Now, some important aspects in the guide is that the guide includes an update to the template statement and license declaration in Annex 2 of the guide. This is a declaration which we discussed earlier. So this declaration now includes a requirement to the owners of the patents to provide information with regard to the relevant clauses of the standard which are relevant for the specific patent. Until recently, the patent holders were requested to provide information only about the standard in general, so the number of the standard and the reference to it. In order to allow the implementers to have a more clear picture for the implementation, now this declaration requests the owners to provide information also about the relevant clauses of the standard. Also, it is requested from the patent holders to provide a hyperlink to the relevant databases of the patent offices. As Jed mentioned, currently there is a link in the ETSI database, for example, with the European Patent Office database itself. This type of information is also important in order to include such link in the CEN-CENELEC database of declarations. Also, it is requested from the patent holders to provide information about any court cases, decisions of courts, or any alternative dispute resolution, which could be relevant to the implementers as information in order to allow them to also go and negotiate with the patent holders for an appropriate licensing. Also, it is very important that this declaration and the patent policy itself require the patent holders to inform CEN-CENELEC in case of any update to the information included in the declaration. This is important because, for example, maybe at the stage when the declaration was made, there was only a patent application. However, if later the patent was granted or the scope was limited, therefore it's not relevant anymore for the specific clause of the standard, or maybe it was not granted. This is very important information which is necessary for the implementers to know. Also, this patent policy, this guide also includes the possibility for the patent holders to agree on arrangements that facilitate or simplify the implementation of the standard through, for example, the patent pools. We mentioned earlier the scenario of the royalty stacking. So the updated guide gives the possibility to the patent owners to agree on such type of formations that can facilitate the implementation of the standard. Also, the updated guide includes in Annex 3 a process with regard to the responsibilities within CEN-CENELEC on how to address the patent declarations. This is a very important and useful tool for the technical committees in order to be able to go through this process and understand themselves what are the next steps, whom they should contact, and to anticipate how this will be addressed. And also, very, very important, there is an updated list of SEP declarations. So the database of SEP declarations is provided on the CEN-CENELEC website. It is now in the form of an Excel spreadsheet, which includes additional columns with all the information, the new information which is requested in the patent declaration, and also includes the relevant hyperlinks with that regard as we have requested. Now, you will see this is already available on the CEN-CENELEC website. This includes patent declarations from many years ago. Now, from declarations since this year, we are endeavoring to include all the relevant information which are requested now. Of course, we have to consider that in the case of CEN-CENELEC, there are, if we may say, not as many declarations as I mentioned at ISO, IC, or ETSI level, which means that it is more easy for CEN-CENELEC to be able to check this information and be able to update and include the relevant links and process them. Imagine the cases of other standards organizations where they have thousands of declarations. This is more challenging, more difficult to do. However, at this stage, this is something which is being handled and is being provided in the case of CEN-CENELEC in the relevant web pages. So you can find this, and in this presentation, we have a hyperlink to that. So here we have, you can see visually how the updated patent declaration looks like, and the relevant information. So nothing has changed with regard to the three options, which I mentioned earlier: free of charge, front, or no license. Only the relevant parts are included about the requirement to update or the requirement to provide information about the specific clauses of the standard which are relevant for the specific patent claims. Now, Annex 3, as I mentioned, is the process which is very, very important. It is a step-by-step approach to help the technical committees in CEN-CENELEC to understand how this works, but also for the patent holders and implementers in case they have any question or issue, to know who can address these questions and at what stage their patent declaration may be, in order to be able to follow up that with that regard. So this information, you can find everything on the updated CEN-CENELEC Guide 8, which is available on the CEN-CENELEC websites, in the annexes 2 and 3. Annex 1 is includes the common ISO IC ITU patent policy. Now, also a facilitation for you, which I do make it a bit easier. We have here the hyperlinks to the revised Guide 8. We have also a hyperlink to the template for patent declarations. This is the updated patent declaration. So in the CEN BOSS and in the CENELEC BOSS as well. So if you need, in the context of your technical committee, to include, to provide such a template to any expert or patent holder in order to be able to declare their patents, please use these hyperlinks here. You can find this also in the relevant databases of CEN and CENELEC. So the CEN BOSS and CENELEC BOSS, they are publicly available to everyone. Also, the list of the SEP declarations, this is also available on the CEN and CENELEC website. It is easy to find. It's the updated version, and of course, we endeavor with time also to update information which is available there, considering also that there is a low volume at the moment with that regard. So, key learning points from this discussion. So, digital transformation is will likely result in increased patent density standards. We see IoT, new technologies are coming towards more traditional standardization areas, which will likely increase the need for interoperability, but also the patent density and the presence of patents with that regard. The patent policy of CEN and CENELEC is very important because it aims to ensure the balancing of the interest between patent owners and implementers, taking into account also the considerations of the stakeholders involved. So this is the core principle of the CEN-CENELEC approach with that regard. If you are at technical committees, please make sure that you inform as early as possible if you're aware of any patent, which could be essential. So it's not to the technical committee to decide if it is in fact essential or not. This is left based on the opinion of the patent owners themselves, and also to request that they fill in the declaration, the patent holders fill in the declarations which are provided in Annex 2 of the CEN-CENELEC Guide 8. Make sure that you use the latest template. We have noticed in some cases that technical committee officers have stored previous templates and use those repeatedly. Please use the latest templates to make sure that all this information can be included in the database of the patent declarations in the CEN and CENELEC websites. And also, in case you want to, if you are an implementer of a standard and you would like to make sure that if there is any patent which is relevant for the specific standard, please check the CEN-CENELEC website where this list is being provided, and this list provides all the information that you may need to identify the standard and the patent, but also check the ISO, IC, ETSI, and other SDOs databases to also make sure that for your standard, particularly in the case of CEN-CENELEC, due to the collaboration with ISO, IC, and ETSI, that there may be corresponding declarations made at ISO, IC, or ETSI level, which may be relevant also for the CEN-CENELEC standards. As I mentioned earlier, CEN and CENELEC adopt standards from ISO and IC, or CEN-CENELEC standards are being taken over and adopted at international level. There are also areas where CEN-CENELEC and ETSI collaborate as well. Therefore, it's possible that a patent holder may have made a declaration at one of the organizations, but not to the others. Therefore, it is very important for you also to check all these databases for information. And then, as Jed mentioned, we collaborate with the EPO. The role of the EPO at the European level and internationally is very important. It's a very critical source of information, and we will continue to engage in order to ensure that there is also a flow of information and knowledge being transferred in the respective communities with regard to the interlinks between standards and patents. So that is from me. I think I will leave to Els now and